So tonight is August 30th. This is our Monday night business law class. My name is Professor Irini Bekhit. I will be teaching you business law this semester. I like to always start the class or the semester by telling you a little bit about myself so you know where I'm coming from. And after that, I'm going to tell you how the class is going to be conducted. And we're going to lecture. We're going to have material tonight that we're going to cover. So I am an attorney. I am a full-time attorney. My day job is an attorney. I work for the Unified Court System, so Surrogates Court, which is, if you're familiar with Staten Island, if you've gone to the Empire Outlets, right across the street from the Empire Outlets, there's a big courthouse there. I work in that courthouse. So that's where I am every day during the hours of 9 to 5. And I have been there now for over a decade, a little bit over a decade. And that's actual employment. That doesn't even include my internship, which was also there at one point. I love my job. I love what I do. I'm very passionate about it. It's very exciting. You're learning things all the time. Prior to being in the surrogates court, I worked in private practice. I worked for a PI firm, personal injury firm on Park Avenue. I worked for a solo practitioner on Staten Island. I've done tons and tons of internships in my life. And so I always recommend that students do internships in the fields that they think they may be interested in, or even if you're not sure if you're interested in it, only because an internship will really give you an idea of what it's like to be in that field. So it's sometimes as important to know what you don't like, what you don't want to do, as it is to know what it is that you want to do. So as far as internships are concerned, I've interned in the DA's office in Kings County. I've interned at the DA's office in Richmond County. I've interned at the American Civil Liberties Union for a professor while I was in law school, for a magistrate judge, for the surrogates court, which is where I work now. So I've had a lot of experiences in all different sectors. And I think that's why, when I found this place, surrogates court, I knew that's where I wanted to be. I knew that's where I wanted to work. I've worked on high profile cases in surrogates court. And I've also worked, right now I do guardianships. So for people who have family members or loved ones who are under developmental intellectual disabilities, I'm the supervisor of that department. And then like I said, I worked on very high profile cases. So the Eric Garner case, that was my case in the surrogates court. Roman Blum, which is a case that people all over the world have heard about, maybe not you guys. It's actually about a guy who died, left an estate of $40 million. And he has supposedly no will. The case is still going on. And he has no heirs. He was a Holocaust survivor. So when he died, if there is no survivors, it would be the largest amount of money unclaimed to go to the state of New York. So sometimes you're like, oh, Uncle Roman, I know him, blah, 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 blah. It's not your uncle, it's not. But if you can try, if you want to try to get that money. So a lot of these cases, I worked on. Staten Island is small. So sometimes you get to see cases of people that you know. And so you have to obviously exercise discretion, but I love what I do. I totally love it. I have long-term goals. My long-term goals are to actually be a TV judge. So like if you ever flip your channels in the morning, if you're home and you're like seeing Judge Judy or any of those judge shows, the goal, the dream is to have one of those shows when I grow up many, many years from now. So we're kind of working towards that. I'm very big on involvement in your community. So throughout the semester, I will be encouraging you to get involved with your community, whether it's a charitable organization, whether it's a religious organization, whether it's a political organization. Thank you. TV judge is awesome. Thank you. What you want to do is you want to be involved in politics, regardless of which political aisle or spectrum that you have. I strongly encourage getting involved in local politics. And the reason for that is that's where you can actually affect the most change. So local politicians who are running for office, they're the ones that are controlling the budgeting that's going into the local community. So when you get involved at the local level, you can have the most impact. So I strongly, especially young people, you have a lot of energy, probably less responsibility than a lot of older folk. And so it's the perfect time to really get involved and network. Networking, again, a big piece of advice I'm going to give you: network, meet people. I know it's super hard right now because a lot of organizations are not taking internships, and that personal touch is lost, but definitely network, meet people, go to events, introduce yourself. I know it's like easier to hide behind a screen, but you really need to put yourself out there. I also love teaching. So I always like to say that as well. Like, I love teaching students. So this is certainly not done for the money. Like, this is not a money thing. This is, sometimes it's not worth the money. Let's just put it that way. But I love teaching students, especially when it was like a live class, a live lecture. It was just so much fun. And I would get home and my husband would be like, "Oh, how was class?" And I'm like, "It was great." And students are so interactive and they have so many questions, and it's awesome. You know why? I feel like I'm able to perform for the students, whereas in the courthouse I can't, because I work for the court. So I have to be impartial. So whenever people are, the other attorneys are fighting for their clients, you have to sit there, poker face, and listen, and then make recommendations to the judge based on the law and whatnot. So performing for students is a kick for me. Although now, like I said, all I see is just black, a screen with like a whole bunch of names, and only Martin is showing his face. And so Martin, again, I thank you for that, because you're the only human being that I see. So I appreciate it. So with that being said, I do hope that this class is interactive. I do hope that you ask questions. I do hope that that you learn something. I also run the largest undergraduate internship program in Richmond County for the court system. And so I used to be able to have, oh yeah, I know that's true. That's why I'm always like tired. Well, the internship program was the largest undergraduate program. And what I've been doing is students who've gotten a B+ in my class or higher, I would offer them, if they contact me, I would give them that internship. And so it's kind of also a way to give back, right? Because sometimes you don't know anybody in that legal field. And unless you grew up with lawyer dads and uncles and aunts and cousins and moms and whatnot, sometimes you don't have that in. And if you're interested in that field, like, how do you even put your foot in that door? And so I like to offer the opportunity to students, especially at CSI, because sometimes students are like, well, we went to CSI because I don't know what I want to do, or you're not sure about what you want to do, or you don't want to spend a ton of money on schooling, and that's completely fine. And so again, it's a way for me to give back. And again, the reason I do all of this, which I didn't tell you yet, is I grew up in a different country. I was born in Egypt. My parents came to this country. My dad first came, I think it was like the 1980s. And then my mom and my sister and I came, and it's a immigrant family. I feel like we're living now the American dream, but my parents worked very hard, 2 jobs each for a very long time. They're older, they're retired now. I work, my daytime, my evening, CSI thing. But growing up, I didn't have anybody that I could go to and say, oh, how do I get into law school? I'm interested in doing this. I didn't have that. So it was always that constant hustle. Like, you have to learn, you have to put yourself out there, you have to try this and try that, and listen to the advice that people are giving you, because that's how you advance. And so again, I've seen a lot of students, sometimes their first generation going to college, or their first in their family thinking about even law school. And so I like to tell students, you could use me as a resource. I have a lot of students, former students or interns, that contact me, they're looking for a letter of recommendation sometime down the line, or they've gotten into law school after they've taken this class, or they thought about law school. And it gives me it like makes me feel all happy and fuzzy on the inside, if I had a small part to do with that. And I will help you kind of reach that step, because it's kind of like paying it forward. You want to help people so they can in turn help other people, and it makes for a better world overall. So that's a little bit about me, family. Like I said in the beginning when I wasn't recording, I have 2 kids, so I gave my little guy my phone so he could be occupied, and my older one is, I think, watching TV right now. My husband works also very hard. He's an OBGYN physician for NYU. So again, immigrant, and we try to reach a lot of milestones, and you work hard, You give back because you are creating a life for your future generations and for your community. So hopefully you are tuning in to all that good stuff. So that's kind of a little bit. So when I teach to give you life knowledge. I teach to give you advice. I try to always make the class about real practical applications. So there are things in the syllabus that I may not spend a lot of time on because I don't feel that it's going to benefit you as much in real life application. And there'll be some topics where we spend a lot of time on because I feel that they are important. And hopefully by the end of the semester, you would retain some stuff that you could use and apply in real life. So with that being said, I'm going to start going over the syllabus. That way you know what I expect. And one of the other things, the reason I tell you about all this stuff that I do, you're probably not busier than I am. So I don't like excuses, right? So at the end of the semester, when somebody, once I give a grade, I don't change it. Or it's like, oh, well, I really need this, I really need a B+ to do well or to graduate. Well, where have you been all semester long? Like you know about the exams, about your the attendance policy. It's all on you, right? You're all above the age of 18. And so it's a responsibility that you have. Whatever you put into this class is what you will get. I treat you guys with respect. I expect that to be reciprocated. It's very simple. All right. Any questions before I start going over the syllabus? No. Okay. So the syllabus is on Blackboard. So there's no shock or anything about, what I'm about to say. You can pull it up right now if you want to take a look at it, when I go over it, but it's very much it's self-explanatory. You have to follow the syllabus. This class is all about reading. So I don't give assignments. I don't give any written assignments. You're not going to have papers. You're not going to have presentations. You're not going to have any of this stuff. You're going to have 3 exams. They're not cumulative. Each exam is worth 30% of your grade, and attendance is worth the other 10%. I tried a couple of different things, over the past few semesters to try to adjust to the whole COVID thing. I did the whole thing with secret phrases or whatnot, but I'm going to just take attendance roll call every class. That way I can mark you're either here or you're not here. If you attend 10 live classes, then you're going to get 100, and 100 will now be calculated as 10% of your grade. I do not give any extra credit. I offered it every semester since I started teaching at CSI, but honestly, I give a deadline, and then I have students who want to submit their stuff, past that deadline. It's a lot of work. It's a lot of work to review it. And then by the end of the semester, when I'm trying to finish your grades and tabulate your final grade to kind of do the extra credit at the very end, you should be working hard towards a good grade all semester long, not just at the very end. So there's not going to be any extra credit. In the exams, there are built-in extra credit questions. So you actually have the potential of getting over 100 on each exam. So you can get 105, you can get 110. And so those points, if you do get it, they help you at the very end of the semester anyway. Okay. Does anybody have any questions so far? Okay. So I do not give makeup exams. The exam dates are on the syllabus. You need to be here. If you're not going to be here for an exam, you're going to get a 0, point blank. You're not here, 0 for that exam. I don't care what excuse you have. You know about it. It's there. So make sure that you make yourself available. By now, we've already had like a year and a half of this Zoom-like, semesters. So make sure that your audio is working. Make sure your Blackboard is working. Make sure you're able to log in and do it. The exams are going to be on Blackboard. It's going to be multiple choice and true and false. That's it. It's not, I don't think that the exams are difficult. That's just my opinion. They are not team projects. They are individually to be done. So you take your exam. Once you're finished with it, you're going to log off and then you'll be done. It's not hard. They're also open book. So there's no reviews. They're open book exams. So easy. The exams are drawn from the lecture material. As you see, the semester goes on. When I'm lecturing, if I tell you, write this down, that means it's important. That means you should write it down. So if I tell you that this is just for listening, that's just something I'm trying to, enlarge your global understanding of the material, just to kind of give you some knowledge, but it's not necessarily for the exam. But when I do say write it down, this is important, it means you should write it down. This is important. I do not tolerate cheating. I look at, if there's 2 students that I suspect have cheated, I will go through their exam. I look at when they did, question 1, question 2, and I will look at, how close their grades are, what they got right, what they got wrong. So if I suspect it and I'm correct in validating my point, you're going to get a 0, you're going to fail the class. Do your exams separately, like be proud of whatever, grade you get. Again, it's as much effort as you're putting in is what the grade you're going to get out of it. If you have some kind of disability that's documented and you need extra time to complete the exam, by all means, contact me and do the proper paperwork, and you can certainly have that. There's no problem. Most students finish the exams within 45 minutes to an hour, they're done. Sometimes students finish in like 20 minutes, a half hour, depends on how much time and effort that they put into studying and prepping every class. You have no right to record my lectures. So it's on the syllabus, and I'm saying it again, I do not give you a right or permission to record this. I'm recording it for educational purposes only, and I post it, so you can go back. But a lot of my lectures are already online. And so if you miss a class, even if I don't post it right away, you can Google Irini Bekhit, YouTube chapter, blah, 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 and you'll find the material online. I think I already mentioned the exams are not cumulative. What does that mean? The semester is broken up into a third, like a third, a third, a third. So the first third, you're going to be tested on that material. You don't need to memorize or understand torts now for the second part of the semester. It's already been covered. There are some topics, legal topics, that build upon each other. And so, the concept of undue influence, you're going to see the concept of undue influence when we talk about wills, and you're going to see the concept of undue influence. It's going to come up when we talk about contract negotiation and corporations and things of that sort. So undue influence is going to come up, but, it'll come up to a particular topic. So again, the exams are not cumulative. What I do is I have an Excel spreadsheet. I plug in your grades at the end, your exams, your attendance, and then that's how I get your grades. And then as you see, there's a grading system on your syllabus. I just kind of see what you got, what your number is and what range it falls in, and that's your grade. And that's it. Very simple. Drop deadline, December 13, 2021. The class itself is broken up by topic. So even if you don't have the latest edition of our textbook, it's okay. You can get whatever is cheaper. Like I really don't care about the edition book that you buy, because the syllabus is broken up to allow you to search for that particular topic in the textbook, regardless of where it is. Okay. Does anybody have any questions on any of the stuff now we just talked about as far as the syllabus is concerned? Going once, twice. Okay. Oh, Hannah, you're also showing yourself. Hello. Okay, another human, yay. It's little things in life that matter. So with that being said, I'm going to start lecturing about the actual material. So today we're going to actually cover some fun topics. I will try to get through everything. The class sometimes could be fast-paced, but the material is fun. And again, I expect you to read before you come into class, because when you read before coming into class, then you're going to have an understanding of the things I'm going to cover. So it makes it easier for you to understand the material. And that's all you have to do. You just have to read. That's the only thing you got to do for this class. Okay. So when we talk about business law, we're going to start first introductory stuff. What is the law? What's the law? Give me a way to describe the law. Anyone? All right. Legal stuff. Thank you. Very good.
Like a system of rules.
It's a, I think somebody just said it. System of
rules.
Exactly what it is. The
Or
law. Go ahead. Somebody just wrote it in also. And Ali, you were saying something? Ali
yeah,
Khan.
I was saying it could be like agreements.
It could be agreements. Yeah. It's a set of rules set by society as right or wrong. Very good. Very good way. Laws are rules that we as a society are expected to follow. Sometimes they're statutory, meaning the law says you cannot kill or you cannot steal, and they have actual, laws written down. And sometimes they are a product of case law. Cases that appear in courts dictate what is then considered as a law or whatnot. Now, if you were to bring morality into this, morally, do you think there's any relationship between morality and the law? Not necessarily. No. Good. Very good. So what happens is with morality, it's not a black or white thing. It's not a yes or no. It's not definitive, because what I may perceive to be morally correct or morally reprehensible may not be the same in your eyes. Prostitution is something where some people say, no, morally, it's fine. It's just a job, whatever. And others find morally, it's absolutely not. It's not good for society, blah, blah, blah. So people have different moral compasses. And so you don't have morality necessarily equating to law. Because again, what you want to be able to discern from reading these cases and reading, the chapters that you're going to be reading is there's no definitive answer to a lot of the questions that I ask, because it depends on the fact pattern. And it could be a case could be very specific and can hinge on one particular fact pattern. I use the word fact pattern a lot. Why? Because I think facts are extremely important in determining the outcome of a case. You could have a very similar fact pattern, two cases, and then at the very end, one tiny fact can be different, but that could be the difference between life in prison or somebody being found not guilty. It could be the difference of $1 million settlement verdict versus $0 settlement verdict, right? So facts in the law are very, very, very important. So you always want to keep that in mind. When we talk about morality, legality, it also gets us to think about the classification of law. How do we classify law? How do we discern what it is? How do we differentiate it? How do we put it into groups? And so sometimes, the law could be just about procedure, or it could be just about substance. So it could be substantial or it could be procedural. And the two together is what attorneys study in order to have, certain outcomes. We can also talk about public and private law. Sometimes the government has its own set of rules and guidelines, and then sometimes there's laws that really are about the relationship of people with people. So there's no government intervention. Sometimes it's like the district attorney's office in a criminal case bringing a case against a citizen, and sometimes it's one person suing another person for money, right? So it's government versus government and people versus people, okay? When we talk about one of the biggest classifications, hold on one second. One of the biggest differences, and we're gonna touch upon that today, is the difference between criminal law and civil law. Okay, so when we talk about civil law, it's when people are suing people. It's usually monetary. And when we talk about criminal law, the outcome is usually an infringement upon freedom, jail time or prison time. So what I'm going to do is now we're going to kind of segue into the criminal law chapter. And the first thing I'm going to tell you that you need to write down, this is now a write it down moment, is the standard of proof in a criminal case. So the standard of proof in a criminal case. You've heard, when I say it, you go like, oh, I've heard this before. In order for somebody to be found guilty in a criminal case, the standard of proof is guilt beyond reasonable doubt. Guilt beyond reasonable doubt. So you've heard it before, I'm sure, if you've ever watched any of those law shows, when you have to be found guilty beyond all reasonable doubt, what does that mean?
There's no chance that you didn't do it?
No chance, or maybe a slim chance?
Slim.
Good. And if you were to equate finding somebody guilty beyond all reasonable doubt, if you were to equate that with a number scale between 1 and 100, how much certainty or proof would you have to show that this person is guilty in order for them to be found guilty? If you were to equate it on a number scale between 1 and 100, what do you think that number would be?
75.
More.
99.
Less.
Oh.
90.
I would say like 90. I would say a
80,
90
80,
to a
90.
95% is
Mhm.
really that level that you need to find. So when a district attorney, an ADA, assistant district attorney, brings a case against someone in a criminal case, they have to prove all those elements of that law beyond all reasonable doubt. So when somebody's now being represented by a defense attorney, that defense attorney's job is to show credible circumstantial evidence that, or alternate theories to show that their client is not guilty. So everything has to be proven beyond all reasonable doubt. Why? Because to take away somebody's freedom, you need that high burden. It's a much higher burden in a criminal case to prove guilt than it is in a civil case to prove monetary damages. Okay? So again, I'll write it down. I always test on this. In a criminal case, to prove guilt, right? You have to prove that a defendant is guilty beyond all reasonable doubt. All reasonable doubt, it doesn't matter. Beyond reasonable doubt, okay? Now this is listening. The court system or the justice system here in this country says that a person is presumed innocent until they're proven guilty. And it shouldn't matter whether or not that person actually testifies for their own benefit. We're going to talk about the 4th, 5th, and 6th Amendment at the end of this chapter. So kind of just keep what I just said in the back of your mind. So somebody is innocent until they are proven guilty, regardless of whether or not they decide to take the stand and try to prove their innocence. Okay. When we talk about punishment for a criminal action, that often involves a couple of different things. You can be fined, right? There could be a monetary punishment. You could be imprisoned. You can be put in prison. You could be put on probation, or there could be death, right? Depending on the state that you're in, perhaps you're guilty, depending on the heinousness of the crime, maybe there's going to be, a death penalty, right? Next part is a write it down moment. Write it down moment. And that's the essential elements of a crime. What are the essential elements of a crime? There's 2 of them. I'm going to put the Latin in your chat and then I'm going to explain it in good old English. So if you want to be cool and you want to talk to your friends in Latin, because that's what every cool person does, you can talk to them about actus reus and mens rea as the elements necessary for any crime. So, what? Okay, fine, go. So when we talk about actus reus, stop it. I'm doing something. Okay. Okay, great. So when we talk about the essential elements of a crime, the actus reus and the mens rea, what is, heard these words on how to get away with murder. Okay, excellent. So do you know what those words mean, actus reus and mens rea, Fifi?
Like I have an idea what it is, but I don't really know exactly like how it participates like here. But I know what it means when you have like when you murder someone.
Okay, and well, it applies not just to murder, it really applies to any crime committed. So let's do them one at a time. Actus reus. What do you think actus reus means? Anyone? If you had to pick one word in the English language,
Act of a crime.
the act of the crime, the actual act of the crime. So if we're talking about murder, it's the actual murder. The murder has to take place, the actual killing, right? So that's the actus reus component, the actual act itself. What about the second component, the mens rea?
Intention.
Intention. Give me another word, because I like to have like mnemonic
Motive.
devices. Huh?
Motive.
Motive, okay, but there's another word that has similar letters to mens rea in it.
Meaning.
No.
The intention.
Mental. It's the mental component, right?
Yeah, the
So that's how
intention.
the intention, right? But think of it with the word mental. It's the mental component. So when we talk about active, this is the way to remember it. Actus reus, it's the act itself. Mens rea is the mental component. Back in the day when we were in live class, I had no problem giving certain examples, but although I told you not to record, I don't know who's going to be recorded or not. Since I'm recording myself and I'm going to be posted, I'm very careful with the examples I give because I don't want it to come back and bite me, later on in life. But so like sometimes, you have a foe or an enemy or, an in-law or, a brother or a sister or somebody that really, really gets on your nerve, right? Professor, student, whatever it is. You could think all you want about, oh, I'm going to get that person or I'm going to do this or I'm going to do that, right? You can think about it all you want. Let's say, I'm going to use this as an example. Let's say Martin, and I apologize, I'm just going to be picking on you because I can see you. Let's say Martin hates this class. He hates me. And he's thinking in his head about how he's going to get me. He doesn't want me to continue teaching this class. He could think about it all he wants. Did he commit a crime? Martin's saying, no, I did not, right? I want to absolve you of all criminal liability, right? What if, now listen to this, I'm going to change it up. No, he has not committed any crime whatsoever. What if, however, Martin or our fictitious person here, because it's not really him, decides to go online and start gathering information about me, where I live, what my schedule's like, starts to Google how to do certain things, starts to buy certain things to help him effectuate his end result. Has he committed a crime then?
I think that's a mens rea because I'm not doing the act yet, but the intentions and like the planning is there.
So you don't think I can get you on anything if I find out about it, or nobody can get you on it?
You can get me, but I think, yeah, you can get me, but it would fall under mens
On what?
rea.
But you need both in order for it to actually happen. Adriana, you're saying yes. Do you want to say why you think that way? Or no? Why is the second fact pattern I gave different or could be perceived as different than the first?
Because he was actually like, buying stuff to commit the crime, like searching you online, like, doing all these things. So I think that's more, active.
Exactly.
Yeah.
There's action there.
Also, that's the actus reus.
Yeah, he is
Yeah.
taking an active step. He is making a substantial step in trying to get his end result. He could be charged on attempted X, Y, and Z, right? Attempted. He failed. His defense is going to be, I didn't go through with it. But the fact that you took an active step to make your thoughts a reality can then be used against you. So that's why I say facts are extremely important. The defense, his attorney would say, let's argue both parts, well, just by him looking her up, just by him Googling this stuff, that's not a substantial step in the effectuation of the crime. Assistant district attorney may argue otherwise. He was getting himself geared up. The only thing left was the actual act. He got his supplies, he knew her schedule, etc., etc. So do you see why facts are extremely important? It can differentiate. And some of you said that's intent, that's motive, right? It's you want to show, and that's why it's important. You'll have two different forces, right? Assistant district attorney for the state and then a defense attorney for the defendant. What's the intent? Well, his intent must have been to harm her because he's taking steps now to do so, right? And so that's when you have whether it's a plea deal or a reduction of sentence or whatever, whatever. But it's important to kind of discern whether or not a substantial step was taken. Now, again, on the exam, I won't give you a fact pattern and tell you because it could go either way, right? A defense attorney can argue one side and ADA can argue the other side. But I just want your brains, I want those wheels to kind of turn to kind of get you thinking. All right. So now this is a listening. Within mens rea, within the mental component, there's actually 3 different types of mens rea. Those are purposeful, knowing, and reckless. I'm going to explain them to you, but again, this is listening. Purposeful mens rea is that you are aware that your intent is to cause somebody harm. Your goal is to cause this person harm, right? That's purposeful. Actions that are going to be taken, the purpose is to cause someone harm. The knowing mens rea is you're aware that the conduct you're taking is prohibited or that it's practically certain to cause harm. You're not 100% sure, but you're almost certain that when you do X, Y, and Z, harm is going to happen. Reckless mens rea is conscious disregard for or an unjustifiable risk that's going to take place. So reckless sometimes is the one that students have a hard time, grasping that concept. If you were to drive 90 miles an hour on Highland Boulevard, what is the likely result of you doing that? If you're familiar with Staten Island or Richmond Avenue. You're driving 100 miles an hour. Ticket, yeah. Accident. Accident is likely to happen. Hurting someone is likely to happen, right? Ticket is absolutely, you're going to get every ticket with all those red light cameras that we have now. Forget that. But when we're talking about intent and criminal behavior, it's you're driving 100 miles an hour. You're likely, you're ignoring the fact that you're going to harm somebody. It's almost a guarantee that that's going to happen. It's reckless behavior. Okay. So those are the 3 possible types of the mental component, which is mens rea. There are also certain types of criminal behaviors that are you're going to get in trouble for them regardless of whether or not you have a defense. There are certain types, and again, this is listening, but like if you sell alcohol to a minor, it doesn't matter if they had a fake ID, it doesn't matter if you thought they looked older, it doesn't matter. You taking that action, you don't even need a mental component for that. Like that is automatically, you're gonna get in trouble for that, right? And the other one is rape. Okay, so there's a certain age, I think, in New York, where if the two people are within a certain age of another, then it might be okay. But you sleep with a minor, you're gonna have a problem. You open yourself up to a huge problem. So don't do it. This I'm not even gonna, I won't even get into that. Okay. The next, this is a write it down. I always test on this also, and that's the difference between a felony and a misdemeanor. So I always test on this. This is a write it down. The difference between a felony and a misdemeanor. A felony, you're gonna be in prison for a year or more. 1 year or more in prison. And a misdemeanor is less than 1 year. So felony, more than a year, prison. Misdemeanor, less than a year, and usually referred to as jail. So if it's less than a year. Okay. Everybody so far good? Let's see what we have here. People do 90, that's not good. Don't do that. Okay. The next is something, it's one of those legal concepts that I had said it's going to come up time and time again throughout the semester. So yes, you need to write it down, but you need to understand it. And this is the concept of vicarious liability. I'm going to write it down, the term itself in here. Okay. Vicarious liability. Vicarious liability is, the definition is when liability is imposed upon one person for the acts of another. So when liability is imposed upon one person for the acts of another. I always give this one example, and then we talk about a couple of different examples to see what you can think of. So a couple of years ago, and I have like no concept of time, so it might have been more than a couple of years ago, there was a Penn State coach that got in big trouble. Does anybody know who I'm talking about and what the details were, surrounding that incident was?
Sandusky?
Yes, sir. Thank you. Do you remember what happened?
It was some sexual assault with his players or something like that.
Correct. And what happened to the head coach?
Got fired.
Now, why did the head coach got fired when it was the other coach, Sandusky, who was doing what? One of them was doing the actual acts, but the head coach is the one that got fired.
Because I think he was responsible. I think he knew about it. He is responsible for taking action on the other coach.
That's right. He knew about what was going on and he failed to take action. So when we talk about the concept of vicarious liability is when liability is imposed, meaning an action will be taken against one person for a wrongdoing of someone else. So let's say I have a store, I own a store, like a Dunkin' Donuts, and I have managers and I have employees. Let's say one of the employees was stealing time and stealing donuts. Who can I go after?
The other employee on that shift or the manager?
The manager. I can actually go after the manager. Why? Because it's the manager's responsibility. Right, Diego. It's the manager's responsibility to make sure that the employees do what they're supposed to do. His or her failure to do that makes them responsible in my eyes. That's why I have a manager in play. Okay? So vicarious liability is, again, imposing liability on one person for the act of another. Does that make sense, everyone? I would say nod your heads, but I only see one here, so it doesn't really matter. You can nod them to yourself if you don't have any questions. All right. The next topic is, this is kind of self-explanatory, but I'm going to say it anyway. And again, you've all read, I'm sure, in preparation for today, so this should not be any surprise. How do you punish a corporation for wrongdoing, whether it's, if it's criminal behavior? How do you punish a corporation?
Sue them.
Let's say I'm the government. How can I punish them?
If they break like agreements, you can punish them, right?
Right? How? Somebody's
By-
already
by
right.
imposing tax.
A
or
couple of people
fining.
wrote it, fine them, right? You impose fines, and depending on the behavior, you can also punish them by prison or jail, depending on the type of behavior that was done. I know you guys are not that young, so when I say the word Madoff, that should ring some bells. Does anyone know what I'm talking about?
Yeah.
Yes, good. What happened with Madoff? Ponzi scheme, excellent. It was the largest Ponzi scheme in the history of the world. And what happened to Mr. Madoff and many of the people on top?
Went to jail.
Prison, big time, right? More than a year. So I think he's serving, I don't know how many hundreds of years as far as his prison sentence. So he got prison time when, again, a corporation, people set up corporations in order to escape liability of that sort. But the behavior was so egregious that not only were there fines and, you know, trying to collect and recoup money to pay to the people that lost all their money and their life savings and whatnot, but there was also prison time for that behavior as well. Good, very good. So that's how you punish a corporation. It could be a fine, imprisonment, or both. When we talk about white collar crimes, right? So now in the chapter that you have on criminal law, they talk a lot about a couple of different types of not only cases, but a couple of different types of crime. Read them for fun. I think it's just fun to know these things. So you talk about white collar crime, and what's white collar crime? You probably have heard the term before. Those are nonviolent crimes, and they usually involve deceit, corruption. It could be embezzlement, forgery, false advertising, antitrust, things of that sort. You have also RICO crimes, and those are usually federal crime that, or federal legislation or laws aimed at organized crime. Okay. Whenever we talk about crimes like that, there are elements. Remember what I said, whenever we have a standard of proof that an ADA has to prove all elements beyond all reasonable doubt or beyond reasonable doubt, and that there are like definitions of actual like murder or robbery or things of that sort. I'm going to give you an example right now of larceny. Okay, I'm going to put this in your chat. This is the actual definition of larceny. You don't have to memorize it, but I want you to understand this concept of elements, the elements of a particular crime. You see how larceny, the definition is trespassory taking and carrying away of or exercising dominion or control over personal property of another with the intent of depriving them, their victim, should be their victim, permanently of goods. That's the actual definition of larceny. So if you were to look it up in a book, that's the actual definition, right? So when somebody is charged with larceny, so an ADA is bringing a charge against someone, right, of larceny, they have to prove each one of these elements. There's 6 elements in here. So if you're not looking at the chat and you just heard me talking, I just said a sentence to you, right? But if you look at the chat, there are numbers associated with certain words. Those are the actual elements that an ADA must prove beyond all reasonable doubt in order to have a conviction, likely or not, of the larceny. If the ADA is not able to prove each and every element, then the defendant is supposed to be able to walk. They cannot be found guilty of larceny if the ADA was not able to show that the defendant had the intent of depriving the victim permanently of goods. Because maybe then the defendant is going to say, no, I did trespass, I did carry away the laptop, which was belonging to somebody else, but I just needed to use it to access my business law class, and then I was going to give it back. I wasn't going to keep it forever. So if the intent of depriving the victim permanently of goods is not there, then the ADA did not prove all of the elements beyond all reasonable doubt, and therefore the defendant should be found not guilty. Make sense? Okay. Moving right along. Okay. Let's see here. Okay, great. Thank you. So the book has a couple of different definitions of a few different things. So false pretenses, robbery, burglary, extortion, bribery. So you can read those for fun. That way you can have an idea of what the crimes are on the and their elements. Okay. Now, we talk about these crimes, and I mentioned it before when we were talking about your classmate here trying to take an action against me, right? And I was talking about like now playing both roles, if I was the ADA versus if I was his attorney. So now we're going to talk about defenses. Okay, defenses. If you are charged with a crime, what are your defenses? There are some defenses that you have that you could use depending on the fact pattern, that you may end up being found, you know, even if you committed a crime, maybe you're going to be found not guilty or even innocent, right? So duress could be a defense that you use. Duress, D-U-R-E-S-S. Duress is a topic that comes up a couple of times throughout the semester. Duress is when you are forced to commit a crime. You did not have the mens rea. You might have committed the actus reus, but you did not have the mens rea. You did not have the mental component. Why? Because you were put under duress. If somebody told you, I kidnapped your child, you are never going to see that child alive again unless you go and rob this bank. You're going to go rob the bank because you want to see your child. Your intention was never to rob this bank. You never wanted to rob this bank, but you were put under duress. Somebody was forcing you, coercing you to take a particular action, right? You can never use, this is a write it down. You can never use reasonable force to protect property. You can never use reasonable force to protect property, but you can a person. So if you've heard that before, let's say somebody hit somebody else, right? They say it was self-defense, right? You've heard that before. Self-defense can be used, and so you could harm someone else if you're harming somebody else for self-defense. If they came at you and then you punched them, they came at you and you shot them and you were defending your own life, that's self-defense. You are not the provocator. If somebody was coming at you, or they stole your bag or your shoes or your wallet and they're running away and you had a gun or a knife or a bat and you decide to beat them so you can get your shoes, your bag, your wallet, can't do that, cannot do that. Why? You cannot use force to protect property, even if it's your favorite pair of shoes, even if it's your favorite purse, even if it's your wallet. You cannot use force to protect property. It's not going to be justified. But if your life was in danger and then you used force, then that could be used as a defense. Does anybody have questions?
I have a question.
Go ahead.
Okay, so if someone said, like, I don't know, bad guy, he's like, I'm gonna tie you up. Can I attack him?
Yes.
Okay, thanks.
You're welcome. Call the police if you're able to. Fifi, you had a hand up. You still have a hand up. Property? Is that what your question is?
What if it's like a property though? Like if someone's like trying to steal your car or like your house or something, then can you like?
You can't shoot them. You can't kill them because it's property,
Can
right?
you
If
hit
somebody's trying to
them?
steal your car, the only exception is your house, your home. And I'm going to get into that into a second. So if somebody's trying to steal your car, you cannot beat them up or shoot them or, you know, harm them or beat them to a bloody pulp to protect your car because the car is considered property. Unless your argument is this car is my home and you're inside of it. So then you're fearing for your life. If you are home and somebody is attacking you in your home, then you can use reasonable force to stop them in your home because most likely you are fearing for your life. If somebody is in your home who is not supposed to be there, you can use force to stop them. Be careful, however, and again, let me be very, very clear. I'm not advocating violence. I'm not telling you how to hurt someone. I'm not telling you how to kill someone. Don't use this at home. You know, this is just legal information. I'm not even giving you legal advice, or I'm not your attorney. I'm just giving you information. I want you to think, Fifi, I see your hand up. Can you hurt them enough to make them stop but not kill them? If they're in your home, absolutely.
Not just
if you're
home,
out in the street,
like everywhere, like in general, when someone's trying to like take your stuff.
you can't, I mean, like, you know, if somebody is trying to take your bag and run and you beat the, out of them where they're, hanging on to dear life, that's not good. That's not, because you can't use force like that to protect property. If you push them away or you slap them or you punch them 1 or 2 punches, all right, you have a case. But if you and 10 other people jump a particular person to stop them from taking your wallet, that's excessive. No, because you cannot use force to protect property. How about they threaten you? Again, if you had, hold on, there's a bunch of things here. So if you have a fear for life, if you're being threatened and your life is in danger, then you can take reasonable force. But that's why it's so important for the facts, right?
How can you argue that though? Like, how can you prove that they threatened you? Because like you can't, like, what if you weren't recording the conversation? How can you prove?
No. But like, if they're just using words, maybe that's not good enough. But if they take out a gun or a knife or a weapon of some sort, then that's threatening, because it's always going to come back to the facts, what happened, right? So that's why facts are so important. If somebody says to you over the phone, I'm going to get you, you cannot go to their house and kill them because you're in fear for your life, because there's no imminent danger. Does that make sense?
Okay.
Then you should be calling the police.
And
be like, this person's threatening me. Get an order of protection. You wrote, I remember my law teacher once told me that if a robber came to steal your TV and tripped on a stair and hurt himself, then you can be sued. Yes, I read about that actually in law school. There was a couple of cases like that. Not only that, but there was also another case where somebody had a booby trap on their window, and then a robber came into the window, through the window, and the BB gun like shot them, and then they sued the homeowner for the injuries that they got when they entered the house to rob them. I said the law. Okay. So what you want to be careful is, so different, it doesn't make sense. Like I would love if you actually spoke, but because I don't know if everybody's reading your messages, and so people might think I'm crazy that I'm just, coming up with these things. So I totally disagree with that. Like, I disagree with that outcome. But the idea behind it is the robber thought to just steal a piece of property, right? Their intent was never to harm anyone. And so they kind of got more than they bargained for, which again, you shouldn't be stealing and you shouldn't be entering people's houses. So me personally, I disagree with that outcome, but there have been cases like that. The other thing I always want to bring up, and I bring this up at every class, is if you are, let's say somebody comes and hurts you, right? In your home or outside your home. And now their back is turned to you and they're fleeing, they're moving away from you and their back is to you. Can you shoot them, use a knife, or you get a bat and get them? Yes or no? But I'd rather you speak up and tell me why. Why, Crit?
No, because they can't defend themselves.
You're correct with the no, but why? It's not that they can't defend themselves.
It's not
But
a fair bargain.
No.
Because they're leaving, so they're not.
Exactly. When somebody's back is to you, it could show that they are no longer an imminent threat and they're fleeing. It's no longer a danger. Their back is to you. They are leaving, right? So then you should not be using that physical force to stop them completely because they're leaving. They're no longer going to be a threat. What if their back is to you, they're in your home and they're going up the stairs to the bedrooms upstairs?
Well, I guess yes, because there was an intent to look for something or somebody.
Somebody, right? So if I have my kids that sleep upstairs and I have somebody, they're not retreating. I see them, they're going upstairs. So even if their back is to me, I'm going to take force to stop them. Why? I might not be protecting myself, but I am protecting other life. I'm protecting human life by stopping this individual from going up the stairs and harming family that's up there. Fifi, I don't know if that's a new hand up or an old hand up.
Old hand.
Okay, thank you. What if the robber had a gun? Give me more. I need more. Give me more of your fact pattern.
Talking about if like the robber came and stole your TV and tripped on the stair, you said that he wasn't trying to hurt you, so you could be sued. But what if he had a gun but wasn't aiming it at you, but it was like on his person, like you could see it?
I would take that. I would take the action to stop them. Look, hold on one second. I'm gonna just